Any favorable result you secure for a client in litigation can be the basis for a thought leadership article. I call this a how we did it article. Whether you're discussing a favorable verdict, a favorable settlement, or even a favorable summary judgment decision, you're taking readers behind the scenes and showing them how you overcame certain obstacles to secure that result for your client. It doesn't matter if you're a plaintiff's attorney or a defense attorney, explaining how you overcame certain obstacles to secure a favorable result for a client signals to referral sources and potential clients or current clients, especially if you have corporate clients, that you should be an attorney they consider referring a client to or hiring directly when they have a legal matter similar to the one you're describing in your article. These How We Did It articles tend to have a simple structure. There's an introduction, there's a conclusion, and then the meat of the article is 3 to 5 obstacles that the author or authors faced while handling a particular matter for a client and explaining how they overcame those obstacles on the way to securing the favorable result for the client. So how do you figure out the universe of obstacles to draw from to get to the 3 or 5 obstacles that will be the meat of a How We Did It article? Well, I'm going to walk through 36 questions that will help get your or your colleagues' gears turning to identify the obstacles that can be discussed in this kind of article. These questions and these obstacles will go from the big picture all the way down to trial, so your mileage and your colleagues' mileage might vary depending on when your particular case resolved. If you want a PDF copy of these questions, get in contact with me and I'd be happy to send you the full list. Before I get into these questions, let me give you a couple caveats regarding these How We Did It articles. First, obviously, let's not disclose anything that is privileged or confidential. Second, let's not disclose anything that is truly proprietary in terms of the way that you might handle a particular case or investigate a particular matter. You should certainly mention that you have a proprietary process for evaluating experts or for evaluating claims or for running a focus group, but you need not go deep into those details if you feel like you have something that's truly proprietary that you don't want to share with the world. And finally, remember, if you're litigating, a lot of the work that you're doing, the outcome of the work you're doing, will be captured in public documents or in public court hearings. So keep that in mind, that maybe the things that you want to talk about aren't going to be impacted by privilege or trade secrets or proprietary information because so much of what you've done is already out in the public eye. With that being said, let's jump into the questions to help get your or a colleague's gears turning regarding obstacles to discuss in a How We Did It article. The first 6 concern the big picture. Where was the case most vulnerable? Which issues required the most creativity? Where did experience and not just hard work make a difference? Was there an obstacle that most plaintiff's attorneys or defense attorneys may have underestimated? Was there a misconception about litigating against certain entities that you had to overcome? Were there challenges regarding co-counsel or conflicts or opposing counsel? The next 4 concern pre-suit investigation and case intake and tend to lean more toward the plaintiff side of things. Were there challenges in unearthing certain facts or documents? Were there challenges corroborating older allegations? Were there statute of limitations concerns? Was there any resistance from the client that made building the case or defending the case complex? Again, are these obstacles that you and your colleagues faced and were able to overcome in order to secure a favorable result for a client? The next 3 questions concern drafting and filing a complaint, which will lean toward, again, plaintiffs. Were there challenges pleading certain facts? Were there challenges deciding which causes of actions to include? Were there challenges in avoiding causes of action that would be easily knocked out by certain defenses? Next question concerns early motion practice. Were there any challenges regarding early motions, dispositive or otherwise, that you faced and that you and your colleagues had to overcome? The next 3 concern discovery. Were there challenges with document discovery? Were there challenges with depositions? Were there challenges with maintaining confidentiality or getting around confidentiality concerns? These next 2 questions concern experts. Were there challenges with your own experts? Were there challenges or obstacles when dealing with opposing experts? The next question concerns summary judgment. Were there challenges with summary judgment motions, whether that would be putting together your summary judgment motion or opposing the other side's summary judgment motion? The next question deals with mediation. How did the mediation process proceed? Did it present any challenges or obstacles for you? This next question concerns settlement. Were there any challenges or obstacles regarding the settlement process, including drafting the settlement agreement and releases? The next questions concern trial preparation? Were there challenges with pretrial motion practice? Were there challenges with pretrial evidentiary rulings? Were there challenges preparing your client to testify? What about challenges preparing other witnesses to testify? And were there challenges in planning your trial presentation? Finally, these last 10 questions concern trial. Were there challenges choosing a jury? Were there challenges with how the trial got started? Were there challenges with any of your direct examinations? Were there challenges with your cross-examinations? Were there challenges caused by the other side's directs or cross-examinations? Any challenges with trial exhibits? How about your or your colleagues' closing arguments? Were there challenges with the jury's deliberations? Were there challenges with any post-verdict motions? Were there challenges with trial publicity? These 36 questions should get your or your colleagues' gears turning regarding obstacles that were faced on the way to securing a favorable result for a client in a litigation matter. These How We Did It articles are quintessential thought leadership pieces. You're showing how you achieved the result for a client, which shows your knowledge and wisdom and positions you as the attorney or referral source your client would be foolish not to reach out to them if they had a matter similar to the one you discussed in your article. For more thought leadership best practices, check out lawfirmeditorialservice.com. We have more than 500 videos, blog posts, and podcast episodes chock full of best practices for thought leadership.